So the recent consultation on the new legislation for the General Medical Council will create a template for the changes for the powers and the approach of all of the healthcare professional regulators that the PSA oversees. There's plans afoot to reform the GMC, the NMC and the HCPC by 2029. So this will mean some big changes coming down the track for professional regulation and some big changes in terms of how professional regulators handle complaints and the experience of complainants within the process. So the new fitness to practice process that will be brought in by the reforms is intended to make proceedings swifter, fairer and less adversarial for people raising concerns and for those that are the subject of concerns. So there's potentially some significant benefits here. So faster resolution may reduce the emotional burden and the duration of complaints handling, particularly for those who may already be experiencing trauma based on the original incident or misconduct. The new process, including the less adversarial model and more flexible case resolution routes, so for example, a new process where cases can be dealt with outside of panel hearings, could also reduce barriers to those engaging with the process and could potentially benefit complainants from groups facing inequalities who may face difficulty accessing regulatory systems. Yes, so this is one of the particular proposals within the consultation, which is to remove from the legislation, which is the GMC's governing legislation, the ability of the regulator to put in place any limits on which complaints they can investigate based on the time at which they occurred. So this rule has actually recently been highlighted as a barrier to families bringing fitness to practice complaints within the Nottingham University Hospital's independent review, which has recently been published. So removing this rule should enable more historic complaints to be heard or investigated, particularly in sensitive cases such as those involving sexual misconduct, for example, where complainants might need more time to consider before they want to come forward with their concerns. And it will also allow the regulator to respond to concerns that valid complaints may previously have been excluded from their investigation processes. So one of the key proposals within the new model is the proposal for regulators to be able to automatically remove from the register anyone who's been convicted of a serious criminal offence. And this is a really important proposal because at the moment regulators have to investigate all concerns if they meet their threshold, but they don't have any ability to sort of fast track it if there's already been a criminal conviction. And obviously there's a lot of merits in suggesting that people who are convicted of a serious offence are not fit to be on the register, so should be removed. So this will allow regulators to take quicker protective action without full proceedings required in the case of serious criminal convictions. So this will send a clear signal about what unacceptable conduct means, and that's, for example, sexual misconduct, that it's incompatible with registration as a health or care professional, and will essentially allow regulators to skip full proceedings for cases of this nature, which should make the process much quicker and less stressful for all of those involved. So the new system will allow regulators to use what are called case examiners, who are members of regulator staff, and they will be able to essentially, in certain cases, to agree an outcome with a professional who's being investigated. So this will allow them to agree the outcome instead of going to a full hearing, which will enable much more proportionate handling of different case types. So, for example, when the registrant agrees with that they've committed misconduct and they agree with the sanction that's being proposed, that will avoid the need to go to a hearing, but should speed up the process of resolving cases and also contribute to a less adversarial model. And this will benefit complainants as well, because they may not need to go through the whole process through to a panel, which can be lengthy and very stressful. So there are a number of proposals for PSA powers within the consultation, but one of the key areas which we think is really important in terms of supporting our oversight of regulators and encouraging a robust approach to complaints handling is a new power for the PSA to compel the regulators to provide us with information. And this should hopefully give reassurance to regulators that they can share information that we need to carry out our oversight. Sometimes there are concerns about data protection. And it will help to ensure that complaints and decisions can be effectively scrutinised by the PSA as well. So as well as our oversight of the regulators to our annual performance review, we also will be able to look at individual concerns as part of our process where we can appeal to the court's decisions that don't protect the public, and we'll also be able to request a revision of certain decisions. So the ability to require information will help to strengthen our ability to carry out our oversight in those areas. So lots of potential benefits, but yes, certainly some risks that we foresee depending on how the reforms are implemented. I think one of the concerns that we have is the increased reliance on cases being resolved by case examiners, so outside of hearings, may limit opportunities for oral evidence or direct participation by complainants. And there is a risk here of complainants feeling a bit more excluded from the process, although the process is far from perfect at the moment, but often there is the opportunity for complainants to be heard in the panel hearing, to give evidence, to give an account of their experiences. The PSA and others have highlighted the importance of ensuring the complainant's voice is still properly heard in the new process. So even when there's no panel hearing, that there's that opportunity for that impact to be understood by those who are considering the concern. And this could be through the use of, for example, witness impact statements or similar, which are used in the criminal justice system. So it's really important that complainant voice is maintained in the new model. So it's been a little bit more difficult for us to establish the impact on inequalities, partly because unfortunately the proposals weren't subject to an equality impact assessment, which we've made this point in our response to the consultation that is important to consider. Evidence from regulators at the moment shows that the current fitness to practice system, the current system for handling complaints, has a lot of impacts on those who are subject to it, and that includes professionals, the registrants who go through it, and we know that there are disproportionate referrals into regulator processes from groups with protected characteristics and differential rates of progression through the process. We also know that from research such as the Witness to Harm project, that there are variable abilities for different groups to access complaints processes. So again, the current process is by no means perfect. There is the possibility that the new model will improve the situation. So there's the potential to reduce inequalities if the system is well implemented. As I've said, making the process less adversarial and speeding things up should have an impact on those who are already differentially affected. However, there is also the risk of exacerbating some of these inequalities if it's not carefully designed and implemented. And that could mean complainants finding it more difficult to have their voice heard. And we know that this is likely to impact on certain groups of complainants more than others. And also registrants may experience greater challenges navigating the process. For example, we know that unrepresented registrants are already at a disadvantage in the process, and that could be exacerbated if the new model isn't implemented well. This is a really key area for us, and probably one of our most significant sort of comments on the new model as part of the recent government consultation. So we think, as we said, lots of potential benefits, but one of the key potential weaknesses of the new model is the safeguards in place for decisions that are made about professionals. So at the moment, the PSA has the ability to appeal to the courts if decisions made about professionals that are regulated by the regulators we oversee don't protect the public. And that's a key public protection safeguard. So we have a couple of concerns with the new proposals. One is that there is a weakness in relation to what's called the new internal appeals process, which will allow essentially professionals to appeal to an internal panel of the regulator if they have concerns about decisions. So decisions of the internal appeal panel at the moment are not subject to any kind of review or appeal mechanism. So if they end up being a final decision about a professional, that could create a public protection loophole, and this could undermine confidence of complainants in outcomes, and also make it harder for complainants and registrants to understand decisions that are made. So this is a key area for us. Another key area which we think really needs to be strengthened to ensure that there can be sort of full confidence in the new system is the process which will be called the regulator revision power, which will mean that decisions made by case examiners, so not those that are made by a panel, will be subject to a new review power. So the regulator will be able to carry out a review if the PSA or another interested party requests a review. And at the moment, we don't think that review power is equivalent or as strong as the appeal power we have for panel decisions. And a sort of key difference is that the grounds for a revision are not in the legislation. So we think that's really important for them to be laid out there transparently, so that the public, complainants, the PSA, everyone can know how and when complaints can be a revision of a concern can be requested. And this is really important from a public protection perspective. So overall, we think the reforms have huge potential to improve speed, flexibility, and the accessibility of complaints handling process. The current system is very much imperfect, and we strongly welcome the opportunity to make improvements for everyone involved in the process. A less adversarial model could significantly improve the complainant as well as the registrant experience. That's a really key positive. However, a key risk is that without robust safeguards, transparency, and equality, diversity, inclusion considerations, the reforms could reduce confidence in the overall model and mimic the complainant voice and potentially even entrench those inequalities. And really, the message is implementation is key. So we've made some specific suggestions for improvement in our response to the consultation on the draft legislation for the General Medical Council. But a lot will also depend on how the GMC operationalises these reforms through careful design of rules and the implementation of safeguards and robust processes to make sure that the experience for complainants is an improvement on the current system.